Let us start with bullet train recap session of course 4 property law second semester KSLU 3 program. I'm going to explain very fast like a bullet train, so I'll cover entire important question along with the answer within 15 minutes. Okay, let us start. This will be useful for your exam day recap. Watch this video at 5 a.m. and finish it by 5:15. Then you start your revision on your own. So we provide more than 7 to 9 modules per subject. One is long notes, then just pause short notes, brief case laws, one-line case laws, last minute points means synopsis, blocks to remember sections on case laws, IMP questions, problems along with solutions and summary of the problems. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 modules. 9 modules we provide per subject to help a student to score more than 80 marks. We will also help student to pass the exam just by studying 20 to 30 pages. Short notes. That is what we call it as short note. Now I'm explaining you with the help of short notes. Short note nothing but this is just a short version of long notes. We explain. We are not giving you the detailed explanation. We are giving you short and brief explanation for each points. For property law, we are providing only 25 pages of all important question along with the answers. This is a theory model. Problem model is different. Okay? So this one is problems. So this is these are the summary of the problems, and this one is problems and solutions. This is a problem. You have to write the explanation of the question, examine, final judgment, justification, case laws, example, everything you have to write. Okay, as per our IQCourt law academic study materials, first question is unit 1, question number 1. Define immovable property, transfer of property law. Discuss the legal requirement and essentials of a valid transfer. This is very, very important. Essentials of a valid transfer. You have to write it up for all the questions. As a general rule, property of any kind may be transferred. Transfer of property means transfer between two living persons. They will ask like this. They may ask like this or this one also. Otherwise, they will ask this one. So you have to write the same answer, but they will ask you a different way to confuse you. So IQCourt law academy student should be perfect, should be fully confident. You will get the question exactly like this in the exam. Okay, so we have combined all those questions. Sthirasti mantu Sottu Astantara, they will also ask Vargavane. All these words we have taken from the real exam questions. Simply we are not adding those words. They will ask like this also. Urjita, Vidibadda, Vargavane, like that they will ask. ಕಾನೂನುಬದ್ಧ ಹಸ್ತಾಂತರ ವರ್ಗಾವಣೆ ಅವಶ್ಯಕತೆಗಳನ್ನು ಕಾನೂನಿನ ಅವಶ್ಯಕತೆಗಳನ್ನು ಅಂತ ಕೇಳ್ತಾರೆ. ಚರ್ಚಿಸಿ. ಒಂದು ಸಾಮಾನ್ಯ ನಿಯಮದಂತೆ ಯಾವುದೇ ಸ್ವತ್ತನ್ನು ವರ್ಗಾಯಿಸಬಹುದು. ಸ್ವತ್ತು ಹಸ್ತಾಂತರವೆಂದರೆ ಇಬ್ಬರು ಜೀವಂತ ವ್ಯಕ್ತಿಗಳ ಮಧ್ಯದ ಹಸ್ತಾಂತರ. ಈ ವ್ಯಾಖ್ಯವನ್ನು ವಿವರಿಸಿ. ಹಸ್ತಾಂತರ ಪಡೆದವನಿಗೆ ಏನು ಹಸ್ತಾಂತರವಾಗುತ್ತದೆ ಎಂಬುದನ್ನು ವಿವರಿಸಿ. ಯಾವ ಸ್ವತ್ತನ್ನು ಹಸ್ತಾಂತರ ಮಾಡಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ. Apavada exceptions, so they are asking. See, if you write all these points, you get really good marks. You can easily score more than 60 marks studying just pass notes. You can score above 80 marks by studying long notes. Transfer Property Law Act 1982. It talks about immovable property transfer between only living persons. Okay, from one living person to another living person. This hand over the duties and rights to transferee. We call this as interviewers between living persons. This is a section. These are key elements, case laws you have to write, and in-depth analysis also you have to explain. What are the essentials, general rules, absolute exceptions. So you can't transfer these things. Okay, you can't transfer these things. Under the Property Law Act. This is the first question. It talks about the immovable property, movement of immovable properties only. Okay. It can be transferred from one living person to another living. ಬದುಕಿರೋರ ಮಧ್ಯೆ ಮಾತ್ರ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋಕ್ಕಾಗುತ್ತೆ. ಈ ಸತ್ತೋಗಿರೋರ್ಗೆ ನೀವು ಪ್ರಾಪರ್ಟಿ ಬರ್ದ್ಬಿಟ್ರೆ ನಮ್ಮ ತಾತ ಸತ್ತೋಗಿದ್ದಾರೆ ಹಿಂದೆ ಅವ್ರಿಗೆ ಹೋಗ್ಲಿ ಅಂತ ಅದೆಲ್ಲ ವ್ಯಾಲಿಡ್ ಅಲ್ಲ. ಬದುಕಿರೋರ ಮಧ್ಯೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬೇಕು. ದಟ್ ಈಸ್ ದ ವ್ಯಾಲಿಡ್ ಪಾಯಿಂಟ್. ಸೊ ಪ್ರಾಪರ್ಟಿ ಲಾ ಆಕ್ಟ್ ಇಟ್ ಡಸಂಟ್ ಸೇಸ್ ವಿಚ್ ಆರ್ ದ ಥಿಂಗ್ಸ್ ಆರ್ immovable property. It talks differently, means negative explanation. Means which are all not immovable property. That is what section 3 of TPA explains. So if you want to see the positive meaning of immovable property, then you have to refer the general clause 1897 section 3. Land things permanently attached to the earth and the benefits arising out of them are called immovable property. So you can transfer property through sale, deed, gift, through other instruments. So when you transfer, the person in transferee will also get the rights and duties. As per TPA Act, it does not include the standing timbers, growing grass, crops. It doesn't include under the immovable property. As per general clause, immovable property means land, things permanently attached to the profit, the benefit arising out of them are called immovable property. Andre benefit. These are the benefit rise to receive the rent, profits from the property, fishery rights, water rights are also immovable property as per the general clause. ಇದು ಹೇಳುತ್ತೆ ಯಾವುದು ಇನ್ಕ್ಲೂಡ್ ಆಗುತ್ತೆ ಅಂತ, ಇದು ಯಾವುದು ಇನ್ಕ್ಲೂಡ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳುತ್ತೆ. ಸೊ ಒಂದು ಲ್ಯಾಂಡ್ ಮಣ್ಣು, ಮಿನರಲ್ಸ್, ವಾಟರ್ ಬಾಡಿ, ಸ್ಪೇಸ್, ಎಬೋವ್ ಇಟ್, ಬಿಲ್ಡಿಂಗ್, ಸ್ಟ್ರಕ್ಚರ್ ಎಲ್ಲ ಹೋಗುತ್ತೆ. ಈಗ ಮನೆ ಕೊಡ್ತೀನಿ, ಐ ಆಮ್ ಗಿವಿಂಗ್ ಯು ದ I'm selling you the house, but I will tell you that window and doors are mine, that I have not sold you. You can't tell like that. You're not going to write windows, that this, you can't specifically write. You will just write all the attached things, like you will be writing it in the sale deed. So all things get transferred to the transferee. Also things attached to the earth. So if you are selling the land, means trees also, machinery, everything gets transferred to transferee. It should be only between the living person. So property you can transfer later or present, but property should be there. So general rule says you can sell anything, but there are exceptions. This thing you can't sell. So when you sell the property, land, building, trees, everything get transferred to transferee. So important point. So you have to write to the first question. What is the legal requirement? Property must be transferable. You can't sell the Vidhan Soda of government office. You can't sell the government office. It should be transferable property. It should be freely transferable. Section 6. Competency of the transfer. Child can't transfer. Transfer must be major, sound mind, and the real owner. Same applies to the transferee. It should be lawful object. You can't sell the government property. It should not oppose to the nature of interest. So and also, if there is any property which it should be registered and stamped and signed. This case law is very, very important. Mohar Bibi versus Damodar Das. You should never forget this case law. You will refer this case law in 3rd, 4th, 5th, every time you will see this case law. Very, very important case law. Then the unit number 1, question number 2. This is the unit number 1, question number 2. Discuss the doctrine of rule against perpetuity. State the exceptions to this rule. Transfer of property act applies to the transfer of interviewers, but transfer for the benefit of unbound person is an exception to this rule. Means property should be transferred only between living persons only, right? But there is exception. You can also sell or transfer it to unbound person. This is an exception. They will ask you to explain. This statement explain the rule and validity relating to the transfer of property made for the benefit of the unbound person. ಶಾಶ್ವತತೆ ವಿರುದ್ಧ ನಿಯಮ, ನಿರಂತರತೆ ವಿರುದ್ಧ ನಿಯಮ ಅಂತ ಕೇಳ್ತಾರೆ. ಸಿದ್ಧಾಂತವನ್ನು ಚರ್ಚಿಸಿ ಈ ನಿಯಮಕ್ಕೆ ಅದನ್ನೆಲ್ಲ ಬರಬೇಕು. ಜೀವಂತವಾದ ಆಗುವ ವರ್ಗಾವಣೆ ಅನ್ವಯಿಸುತ್ತೆ. ಆದರೆ ಹುಟ್ಟದಿರುವ ವ್ಯಕ್ತಿಗಳ ಪ್ರಯೋಜನಕ್ಕಾಗುವ ವರ್ಗಾವಣೆಯು ಈ ನಿಯಮಕ್ಕೆ ಅಪವಾದವಾಗಿದೆ. ಈ ಹೇಳಿಕೆಯನ್ನು ಚರ್ಚಿಸಿ. ಜನಿಸದಿರುವ ಹುಟ್ಟದಿರುವ ಅಜಾತ ವ್ಯಕ್ತಿಗೆ ಪ್ರಯೋಜನಕ್ಕಾಗಿ ಮಾಡಿದ ಸ್ವತ್ತು ಹಸ್ತಾಂತರಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ನಿಯಮಗಳನ್ನು ಸಿಂಧುತ್ವವನ್ನು ವಿವರಿಸಿ. That is very, very important question. 200% important question. High probability is there. They will ask this question. This is the most important question. See, you should sell the property from one living person, another living person. But there is an exception. You can sell it to unbound, transfer it to unbound person also. Before transferring, you have to make prior life interest. Means you have to give life interest to the living person. After B's death, you can transfer to, you have to write the say deed like that to unbound person. This is what we call it as transfer for benefit of unbound person. Section 30. ನಾವು ಯಾವಾಗಲೂ ಓನ್ಲಿ ಲಿವಿಂಗ್ ಪರ್ಸನ್, ಒಬ್ಬ ಇನ್ನೊಬ್ಬ ಬದುಕಿರೋ ಮನುಷ್ಯನ ಜೊತೆ ಮಾತ್ರ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬೇಕು ರೂಲ್ಸ್ ಹೇಳುತ್ತೆ. ಆದರೆ ಒಂದು ಎಕ್ಸೆಪ್ಷನ್ ಕೊಟ್ಟಿದೆ. ಅದರಲ್ಲಿ ವಿ ಕ್ಯಾನ್ ಆಲ್ಸೋ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಅನ್ಬಾರ್ನ್ ಬೇಬಿ, ಬಟ್ ದೇರ್ ಆರ್ ಸಮ್ ಕಂಡೀಷನ್ಸ್. ಸಿ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಇಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಇನ್ ಟು ಹಿಸ್ ಸನ್ with a life interest. Means till you die, you keep it. After that, it should be transferred to your upcoming baby. After the baby's death, it should be transferred to unborn person. But at the time of his death, baby should be at least conceived in the womb. ಅವರು ಹೊಟ್ಟೆಲ್ಲಾದ್ರೂ ಇರಬೇಕು ಮಗು. ಅವನು ಸತ್ತೋದಾಗ ನೀನಪ್ಪ ನಿನ್ಗೆ ಹೋಗ್ಲಿ ಆಸ್ತಿ, ನೀನ್ ಮಾರಕಲ್ಲ, ಬರೀ ನೀನು ಬದುಕಿರೋರಿಗೆ ಯೂಸ್ ಮಾಡು. ನೀನು ನೆಕ್ಸ್ಟ್ ನಿನ್ ಮಗಂಗೆ ಹೋಗ್ಲಿ, ಹುಟ್ಟ ಮಗು ಇನ್ನೂ ಹುಟ್ಟಿಲ್ಲ. ಬಟ್ ಇವನು ಸಾಯೋ ಟೈಮ್ ಅಲ್ಲಿ ದಿಸ್ ಬೇಬಿ ಶುಡ್ ಬಿ ಅಟ್ ಲೀಸ್ಟ್ womb ಇರಬೇಕು. ಸೊ ಇಟ್ ಶುಡ್ ಬಿ conceived in womb. Then transfer of absolute interest. See, transfer to the unborn baby should be absolute interest. No limited instruction. Means you can't sell like, okay, you take it, you use it till you die. Again, that should be transferred to your upcoming baby till it die. And later, you should go to his son. Like you can transfer to his living person as a trustee. Then finally, you should give the final, full, complete transfer to his unborn baby, upcoming baby. This is the condition. At the time of death, the baby should be inside the womb. Then only it will be valid. Baby should get the full, complete rights, okay, in the property. But transfer can be postponed to the baby till the age of 18. Beyond 18, they can't transfer. See, baby will get the full property rights. Means baby, that property gets transferred to the baby, unborn baby. But till the age of 18, the possession and enjoyment can be postponed. Possession or enjoyment ಅಂದ್ರೆ ಬೇಬಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗುತ್ತೆ, ಆದ್ರೆ ಬೇಬಿ ಯೂಸ್ ಮಾಡಬಾರ್ದು. ಅದನ್ನ 18 ಏಜ್ ವರೆಗೆ ಯೂಸ್ ಮಾಡೋದು ಬೇಡ ಅಂತ ಬೇಕಾದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬಹುದು. ಸೊ ಒಂದು ಬೇಬಿಗೆ 60 ವರ್ಷ ಆಗೋವರೆಗೆ ಯೂಸ್ ಮಾಡಬೇಕು, ಆ ತರ ಎಲ್ಲ ಮಾಡೋದಕ್ಕಾಗಲ್ಲ. ಓಕೆ, ದಟ್ ಇಸ್ ವೆರಿ, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್. ಸೊ ದಿಸ್ ಥಿಂಗ್ ಆನ್ ದಿಸ್ ಮಚ್ ಓನ್ಲಿ. ಸೊ ಯು ಕ್ಯಾನ್ ಹೋಲ್ಡ್ ದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಅಂಡ್ ಎಂಜಾಯ್ಮೆಂಟ್. ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಯು ಕ್ಯಾನ್ ಹೋಲ್ಡ್ only till the life of the living person plus 9 months in the womb time plus till the age of 18. This is a maximum time you can postpone. So in this case law, it says for transfer to unborn person to be valid, the interest must be absolute. Very, very important. But in these cases, that limit won't apply. 18 this year limit won't apply. For public benefit, personal agreement, for these things, that limit won't apply. ಈ ವರ್ಷದಲ್ಲಿ ಹೋಗಬೇಕು, ಇಷ್ಟು ವರ್ಷದಲ್ಲಿ ಹೋಗಬೇಕು, 100 years ಆಗತ್ತೆಲ್ಲ ಬರೀಬಹುದು. They can write 100, 200, 300 years also. Here they can't restrict the property. Property should flow from one person to another person. It should not get stuck with one person. That is the reason the rule against perpetuity came into picture in the Transfer of TPA Act. Then the third question, explain the effect and provisions relating to the condition restraining the alienation of property and condition in restrictions of enjoyment of the property transferred absolutely with exceptions. An absolute restraint on alienation is void, but partial restraint is void. So partial restraint is valid. Partial ಆಗಿ ಇದಕ್ಕೆ restraint. ಸೊತ್ತು ಸಂತ ತಡೆಹಿಡುವ ಷರತ್ತಿನ ಪರಿಣಾಮವನ್ನು ವಿವರಿಸಿ. ಸಂಪೂರ್ಣವಾಗಿ ವರ್ಗಾಯಿಸಿದ ಸೊತ್ತಿನ ಅನುಭೋಗ ಮಾಡುವ ಹಕ್ಕಿನ ಮೇಲೆ ನಿರ್ಬಂಧ ಹೇರುವುದು ಷರತ್ತುಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ನಿಬಂಧನೆಗಳನ್ನು ಅಪವಾದಗಳೊಂದಿಗೆ ವಿವರಿಸಿ. ಪರಬಾಧೆ ಮಾಡುವುದು ಸಂಪೂರ್ಣವಾಗಿ ನಿಗ್ರಹಿಸುವುದು ಕಾನೂನು ದೃಷ್ಟಿಗೆ ಶೂನ್ಯಕರಣವೆಂದು ಅಂಶೀಯ ನಿಗ್ರಹವು ಶೂನ್ಯವಾಗಲಾಗದು. ಅಂಶ ಅಂದ್ರೆ ಪಾರ್ಟ್. Property sell, even person A is selling the property to B and is putting the condition that you should not sell this property anyone else. Nobody can do like that. But he can put condition like sell only to the property. Reasonable limit. That will be valid. That's what it says. Section 10. This is very, very important. You will get it for the problems. Also theory, very, very important question. See, once you sold the property, you can't put restriction that you can't sell it to other person. Like A is sell the property to B with condition that B shall never sell this property until his death. Like that, he can't put the proper condition. What happens if the people who puts the condition? Court will make this transfer as a valid, but court will remove that condition. That's it. That B can freely transfer the property. In this case, A gives the mango garden to B with the condition B shall sell it only to the family. This is valid. Court will consider this. This is what we call it as partial restraint. It is a valid one. We'll go to fourth question. Explain the meaning of vested interest and contingent interest. Means it will go, the interest will go immediately. This will go after the specific event. Legal rights, passing of legal rights. It should decide, it will explain exactly when you get full property rights. In this, you will get the property rights immediately. In this, you will get after the specific event. That's it, nothing else is there. See, in this, section 19, rights will be created immediately. You will get the legal rights. But enjoyment can be postponed. Immediate ಆಗಿ ಒಂದು ಸಿಕ್ಬಿಡುತ್ತೆ ಆಸ್ತಿ, ಬಟ್ ಒಂದು 5 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ನಿಂಗೆ ನೀನು ಯೂಸ್ ಮಾಡಪ್ಪ ಅದನ್ನ ಮನೇನ ಅಂತ ಹೇಳ್ಬೋದು. ಬಟ್ ಇದರಲ್ಲಿ ಕಾಂಟಿಜೆಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಸೆಕ್ಷನ್ 21 ಏನು ಹೇಳುತ್ತೆ ಅಂದ್ರೆ, ನೀನು ಆ ಹುಡುಗಿ ಮದುವೆ ಆದ್ರೆ ಮಾತ್ರ ಈ ಮನೆ ಸಿಗುತ್ತೆ. ಇಫ್ ಯು ಮ್ಯಾರಿ ದಟ್ ಗರ್ಲ್ ಓನ್ಲಿ, ದೆನ್ ಓನ್ಲಿ ಯು ವಿಲ್ ಗೆಟ್ ದಿಸ್ ಹೌಸ್. This is what we call it as contingent interest. Section 21. Uncertain event, whether you will marry or not, we don't. Such transfer, we call it as contingent interest. Transfer may happen, may happen, may not happen. Rights, they will get, definitely they will get the rights. Here they may get, they may not get. Enjoyment can be postponed, but here full of uncertainty. Essentials, ವಾಗುತ್ತೋ ಡೌಟ್, ಅವ್ರಿಗೆ ಮದುವೆ ಆಗ್ತಾನೋ ಇಲ್ಲ ಬೇರೆ ಹುಡುಗಿ ಮದುವೆ ಆಗ್ತಾನೋ, don't know, right? See, they can't enforce it till the event happens. See, example, A gives property to B on condition that if B crosses the river Ganga in a boat, so that event happens or not, we don't know. That is what we call it as contingent interest. Only if you marry that girl, then only this property will get transferred to you. Then we call it as contingent. Section 21. This is vested interest. Immediate it will get transferred. Immediate. So in this case, A gives the life tenant to B, but he is giving the vested interest to C. Means he is transferring the property to C, but he is writing that till B is alive, he has the right to enjoy. Means he is just postponing the enjoyment and possession of the property. This is about a notice. You get it for 8 marks versus 16 marks. So very rarely they will ask. It's very important. Then we'll go to second unit. This is related to doctrine of election. When can it be presumed? A person who accepts the benefit from the instrument shall also take the burden of it. ಆಯ್ಕೆ ಸಿದ್ಧಾಂತಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಒಪ್ಪಂದವನ್ನು ವಿವರಿಸಿ. ಯಾವಾಗ ಇದರ ಬಗ್ಗೆ ಪೂರ್ವ ಭಾವನೆ ಸಾಧ್ಯ? ಒಬ್ಬ ವ್ಯಕ್ತಿಯು ಪತ್ರದಿಂದ ಬರುವಂತಹ ಲಾಭವನ್ನು ಪಡೆಯುವನು, ಅದರಲ್ಲಿರುವ ಹೊಣೆಗಾರಿಕೆಯನ್ನು ಕೂಡ ಸ್ವೀಕರಿಸಬೇಕು. ಮೀನ್ಸ್ ನಿಮ್ಮ ಮದರ್ ಹೇಳ್ತಾರೆ, you take my property. Your mother is saying, you take my property. Your mother is telling to A, you take my property. In the same agreement is also mentioning on the condition that A's property should give it to B. If A is accepting B's property, he has to ready to give up his property to B. That is what we call it as doctrine of election. Under this section 35, doctrine of election ensures fairness. If person happily accept a sweet benefit from a document, they must compulsorily carry the heavy burden inside it. They should accept both, burden and benefit both. Otherwise, they have to reject the both. They can't say, I will accept the gift, I will not going to accept the burden. They can't say that. Meaning and concept of election, then a person who accepts the benefit shall take the burden. Discuss. You have to explain this valid condition of the election also you have to explain. When can the election be presumed? Presumption of election. Consequences of rejection and death of the transferee, exception to the rules. All these things you have to write. Then we'll go to unit 2, question number 2. Who is an ostensible owner? Define the concept of transfer of property by ostensible owner. What are the consequences of such transfer, and when does a transferee from an ostensible owner gets a good title and safeguards against a real owner? ತೋರಿಗೆ ಯಜಮಾನ ಎಂದರೆ ಯಾರು? ವ್ಯಾಖ್ಯಾನಿಸಿ. ಅಂತ ತೋರಿಗೆ ಯಜಮಾನ ಹಸ್ತಾಂತರದ ಪರಿಣಾಮ ಏನಾಗುತ್ತೆ? ಅಂತ ತಗೊಳ್ತಾನದ ಪ್ರಾಪರ್ಟಿ ತೋರಿಕೆ ಯಜಮಾನಿಂದ ಅವನಿಗೆ ತಗೊಂಡು ಪಡೆದವನ್ಗೆ ನಿಜವಾದ ಒಡೆತನದ ವಿರುದ್ಧ ಯಾವಾಗ ಉತ್ತಮ ಹಕ್ಕು ಪಡಿತಾನೆ ಮತ್ತೆ ಅವನಿಗೆ ಏನೇನು ಹಕ್ಕು ಸಿಗುತ್ತೆ? A fake person who looks like a real owner in society and government record, but real owner secretly lies with someone else. Means these are benami property, like a benami property. Section number 41. This is the important question. Example: a rich father buying a land in his son's name. His son is the ostensible owner, makes the son as an ostensible owner, but a simply poor tenant owner ಬಾಡಿಗಿರ್ತಾರಲ್ಲ ಅವರೆಲ್ಲ ತೋರಿಕೆ ಯಜಮಾನ ಆಗಲ್ಲ, ಸುಮ್ಮನೆ ಡಮ್ಮಿ ಯಜಮಾನ, ಡಮ್ಮಿ ಓನರ್. So you have to write the concept, you have to write the consequences of such transfer. His son will transfer to his friend or girlfriend. What is the consequence? Actually, all the money invested by the father, he bought the property in his son's name, son sold it to his girlfriend. So here now, as per the government record, son is the owner, so he can sell it to his girlfriend, no problem at all. What happens? Consequences. When does the transferee get the good title? Safeguards against the real owner. So consequences also you have to write. When does the transferee get a good title? ಯಾವಾಗ ಒಳ್ಳೆ ಹಕ್ಕು ಸಿಗುತ್ತೆ ಟ್ರಾನ್ಸ್ಫರಿಗೆ? If the girlfriend and son both together plan to cheat this father, then the girlfriend will not get. So it should be bite with a good faith. So landmark case laws you have to write. Then unit 2 question number 3, explain the doctrine of Lis Pendens. 200%, 300, 500% important question. Okay, transfer made during the pendency of litigation in the Transfer of Property Act with the help of suitable illustration on the case laws. Means nothing. This is very simple. It is only to save the public policy. It forcefully stops the people from selling the disputed property while court fightings are pending. See, court ಅಲ್ಲಿ ಕೇಸ್ ಆ ಟೈಮಲ್ಲಿ one person ಇನ್ನೊಬ್ಬ personಗೆ ಸೇಲ್ ಮಾಡ್ಬಿಡ್ತಾನೆ. Court will give judgment. Then what is the will tell A and B are fighting for a specific property. During this court case, B sold this property to C. Then court says this property belongs to A. Then again, A has to struggle to get the file the case against C and B. Right? This should not happen, right? This doctrine gives the high priority to judgment. So Section 52 says, while the court cases or property is actively pending, nobody can secretly sell it to new person. Any new buyer is secretly bound by the final judgment order, even if they had no choice, no notice. Essentials of the doctrine: pendency should be there, case should be pending, it should be before the competent authority, competent court. Next, the fight must be real, not a fake planned one to cheat someone. Right to movable property directly in question. Transfer by a property to the suit must affect the rights of the other owner. If the secret sale must actively damage the property rights of the in this case only this lease pendency doctrine will apply. You can't sell the property to anyone else when there is a litigation in the court, when the court case is pending before the court. But there is an exception. Through court or if you are selling, this lease pendency doctrine will not going to apply. Then question number 2, unit number 2, question number 4, part performance. It's very simple. Under section number 53A, if an honest buyer pays the advance, some amount he has paid for 1 crore property, he has paid 10 crore advance, and he moved into the house. He paid the advance and there is a contract, and he is told he will pay the remaining amount on specific date. During this time, the real owner got another offer for 2 crore. During this time, he can't throw this person because he is ready to pay off on the specific date. Agreement is already over. So that is what it says. The greedy seller can't legally throw him out just because registration is pending, because full payment is not done, registration is pending. So he can't throw the person who is already paid the advance amount and already taken a physical possession of the property. Essentials of the part 4. These are the essentials. It should be returned, immovable property, consideration should be there, possession should be there. Buyer must compulsorily move in and hold the keys. Buyer must actively pay some advance money. Willingness should be there. Buyer must be totally ready to pay the remaining balance. This is very different, important. Indian case, this is not that important, but this is very important. Fraudulent transfer is very, very important. These are the circumstances, exceptions, case laws, you have to write. Then we'll go to 5th question. This is a lease pendency. When there is a case, you can't sell it to someone else. The property can't be sold to someone else. Even if sold also, it will be subjected to court order. If it is in this favor of same person who bought the property, then who sold the property, then it will be valid. If A is selling, A and B are fighting for a specific one property, B sold the property to C during the lease pendency when the case is before the court given the judgment decree in favor of B. So this transfer will continue to become valid. If you sell the property during the litigation, after judgment, if the property comes in favor of B who sold the property to C, then he can continue to hold the property. This sale will be valid. No need to again do the registration. There's no need of that. See, A and B both agreed and he paid the advance, then both moved, took the position. Now he can't, seller can't stop him. Just because registration not happened, I am got another offer. So you can't sell like that. You can't tell like that. Okay. Fraudulent transfer, section number 53. Very, very important. Very, very important. I'm telling you, this is very, very important. 200-300% important. The part performance and fraudulent transfer both are very, very important. The fraudulent transfer is there, right? This is 95% important question. 50 section 53 and this also very, very important. 53 also important. Part performance both are very, very 95% important question. What are remedies available for the improvement made by the bona fide holders under a defective title? You are the money in the purchase ಮಾಡ್ತೀರಾ, but A sold the property to B, means land to B, then B constructed a beautiful house spending 1 crore rupees. Now C is saying, I'm the real owner. A is not the real owner. What happens? You have to explain. He purchased the property, now he's saying this is my property. So he's a genuine buyer. So in this case, this person has to pay to the buyer who bought the property for whatever he spent for constructing a house, whatever he spent for that. or he can buy he should buy the property at the market price. If the real owner will not pay, he must sell the property to the, if he is saying I will not going to I can't pay for the whatever the improvement you have done, whatever the construction, in that case he has to sell the land to this person, the bona fide holder under defective title. The essentials for the section 51 is belief of the observed owner. He thought that I am the real owner, good faith should be there, honesty should be there, must not have acquired through will. In the third unit, define mortgage and explain the essentials of the mortgage. Explain the various kinds of mortgage. Specifically include these are the various kinds you have to explain. Mortgage though, Adamanadu explain ಮಾಡಿ essentials ಎಲ್ಲ explain ಮಾಡಬೇಕು. This is very important question. Very, very important question. For this question, you have to write the definition and legal key terms, explanation, examples, essentials of a valid mortgage, and various kinds also you have to write down. Legal terms, mortgager, mortgagee, everything you have to write. Legal terms, everything you should write. Then question number 2 of Unit 3, right of redemption, statutory rights that can't be contracted out, and explain what is clause on right of redemption. Also discuss the principles of once mortgage is always mortgage, and comment on whether the right to redeem and foreclose down are coextensive. ಅಡಮಾನಗಾರನ ಋಣ ವಿಮೋಚನಾ ಹಕ್ಕನ್ನು ಶಾಸನೀಯ ಹಕ್ಕಾಗಿದ್ದು ಇದನ್ನು ಕರಾರಿನಡಿಯಲ್ಲಿ ಬಿಟ್ಟುಕೊಡಲಾಗುವುದು ಎಂಬುದನ್ನು ವಿವರಿಸಿ. ಋಣ ವಿಮೋಚನಾ ಹಕ್ಕಿನ ಮೇಲೆ ನಿರ್ಬಂಧ ಅಂದರೇನು, ಒಮ್ಮೆ ಅಡಮಾನ ಯಾವಾಗಲೂ ಅಡಮಾನ ಆಗಿರುವ ಸಿದ್ಧಾಂತವನ್ನು ವಿವರಿಸಿ. ವಿಮೋಚನೆ ಮಾಡುವುದು ವಿಮೋಚನಾ ವಿರೋಧದ ಸ್ವಾವ್ಯಾಪ್ತಿಗಿರುವ ಬಗ್ಗೆ ವಿಮರ್ಶಿಸಿ. Under Transfer of Property Act 1882, making the mortgage means giving the temporary rights of a immovable property to someone, just a strong law for a loan. For loan purpose, you are giving your property for mortgage. That's it. Very simple. A poor borrower giving the property is a mortgage. The rich lender giving cash is a mortgage. Very simple. Very simple. IQCourt law administrative methods are very simple, very easy to understand. You'll feel like keep on studying. You have to write the rights of redemption, statutory rights that can't be contracted out. What are rights available to the mortgager? Statutory rights that can't be contracted out. And clause. See, lender can't stop you from taking your property back. This is what we call it as clause. It is a tricky rule that make paying the paper, make it impossible to get your property back freely. For example, forcing you to pay extra lifelong tax to the lender. Like this, if they put the condition, it will be valid. It will not be valid before the law. Explain the rights and duties of the mortgagee in possession. Under the what circumstances can the mortgagee sell the mortgage property without intervention of the court? Without intervention of the court, when can they sell? Rights of the mortgagee, you have to write the introduction, right to foreclosure, right to sue for the mortgage money, right to appoint a receiver, liability of the mortgagee in the possession. This thing you have to write. This is very, very important. Sale without intervention of the court. Very, very important. Section 59, Section 69. Law gives VIP lightning fast power to the lender to sell the directly on the street without the judge's permission. Only in this type of mortgage. Then unit number 4, question number 1. Define sale. Distinction between sale and sale of say, a contract for sale. Between sale and contract for sale. Explain the rights and liability of the both seller and buyer before and after completion of the sale. Very important. Very easy question. Very important. This is a 200% important question. This question also came in contract also, in property also. Is sale means it's an absolute transfer, complete transfer, immediate transfer to another person for a fixed price. Contract for sale means under section 54, it's just a future agreement. It simply creates the personal obligation to finish the sale. Agreement not clause. Okay. Differences you have to write, case law you have to write, explanation you have to write. Rights and liability of the seller, rights and liability. Seller before the sale, after the sale, this is very, very important. Simply writing some stories, they will not give marks. Liability of the seller before the sale, rights, again, liability and rights. After sale, this is before sale. Here also before sale. So you have to write like this. Again, for buyer also, liability of the buyer before completion of sale, rights before sale, liability after sale and before sale. Like that you have to write. Unit number 4, question number 2. Define lease. Lease of the essential requirement for a validly explain how a lease is affected and created. Discuss the rights and liabilities of a leaser and lease. Explain the various circumstances and modes of the determination and termination of the lease. Lease means very simple. Enjoyment without ownership. Example, rent ಕೊಡ್ತಿರಲ್ಲ rent. Regarding that, you have to write essentials of what he can do, what he should not do, how it will be created, what are the liability and the rights of the lessor and lessee. ಬಾಡಿಗೆ ಕೊಟ್ಟವನು, ಬಾಡಿಗೆ ತಗೊಂಡವನು, ಬಾಡಿಗೆ ಕೊಡೋನು, ಬಾಡಿಗೆ ಓನರ್. You have to write for this question. You have to write essentials, party, ಸಕ್ಷಮ subject, ownership, everything you have to write. How a lease is affected and created. Rights and liability of the lessor, rights, liability of the lessee. Termination of the lease. Termination or determination of the lease. Very, very important. They will ask this one. Very, very important. Determination or termination of lease. Then third one, gift, ready notifications of the gift. This is a very basic question. You can easily study and write. The 4th unit is very easy. Donor and doning, dana grahi. You can write your own essentials. You have to write. Concept of owner's gift under section 127. This is also very, very important. So when you are taking the gift, which is having a 10 lakh bank loan, you should ready to accept that also. When you are receiving a gift, explain the concept and revocation of the gift. When it can be revoked, those much if you write is sufficient. And the essentials of the gift. Then we'll go to 5th unit. These are the valid essentials of the gift means it should be voluntary without consideration. You must be competent who is giving. To any living person can be doning. No need to be major. He can be minor also, but must be alive at the time of gift. Unborn child also can be donee through the trust, making someone trustee. But donee should accept it. That is essential, very, very important. exception should be there. Transfer of the position. Actual position must be transferred to the donee. Or transfer to ಇವರೇ ಇದ್ಬಿಟ್ರೆ ಮನೇಲಿ ದಾನ ಕೊಟ್ಟದಲ್ಲ ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳೋಣ ಅಂತ ಆ ಥರ ಎಲ್ಲ that will not be valid. All those things you have to write. Define trust. Explain the procedure for creation of a trust. Explain the various kinds of trust as given in the Indian Trust Act. It is very, very important. Definitely read one question from this. Sometimes they are giving two questions also. One is for 60 marks, another one is 8 marks. If you don't have time, you just please study points, headlines. There are two questions I have given. One is the procedure of creation, key parties, essentials you have to write, and kinds of trust you have to write. This is very, very important. Sometimes they will ask what are the kinds of trust they will ask. So distinction means distinction between trust and bailment. What is the difference? Definitely they will ask this like this also. Very, very important. Trust and agency also they will ask. Discuss the rights, liability. This is very, very important. One of these two questions will be definitely there in the exam. So very, very important question. Rights and duties you can write. It's a very easy question. You can write it on your own. So he is the author, means giver. He is a trustee. This property will give it to him just for them as a trustee. He is not going to, he can't use this property as his own. He has to follow the instruction given by author, creator of the trust, for the benefit of the beneficiary. Here author will be there, trustee will be there, beneficiary will be there, and trust deed will be there. As per the trustee has to work for the benefit of the beneficiaries. It is essentials, it should be lawful object, it should be there, reasonable class, certainty should be there, transfer of property, acceptance by the trustee should be there. He must accept it to become a valid trust. So you have to write the difference also. Trust agency, trust, bailment. Rights and duties also you have to write. Duties of the trustee, liability of the trustee, beneficiary duty, beneficiary, liabilities also you have to write. He is the author creating that trust and trust deed we call it as. Then he will give it to trustee for the benefit of beneficiaries. See, he will work as an like an agent. He work as per the instruction of the author, and whatever he is told, like the on the as according to that, he will give the benefit to the beneficiaries. Okay, ಮನೆ ಕೊಡ್ತೀನಿ, ಮನೆಯಲ್ಲಿರೋ ಈಗ ರೆಂಟ್ ಕೊಡು, ಇವು ಬರೋ ದುಡ್ಡನ್ನೆಲ್ಲ ನನ್ನ ಮಗ ಓದ್ತಿದ್ದಾನಲ್ಗೆ ಅಲ್ಲಿ ಕೊಡು ಅಂತ ಹೇಳಿರ್ತಾರೆ. ಸೊ ಆ ತರ ಇವನು ಕೆಲಸ ಮಾಡ್ತಾನೆ ಅಷ್ಟೇ. What are the rights and duties? Everything you have to write. If you are not unable to remember the section, just write like this: 31 to 35, 36 to 45, 55 to 69. Then you can write the section range of sections. Very simple, very easy. Okay, all the best for your exam. This is a quick recap of property law. Today date is 27th July 2026. Your exam on 28th July 2026. All the best. We also provide the last minute points, case laws. You can just study at least one or two case laws per question. One case law per question. Don't skip case laws. You can revise the last minute points. Synopsis also I've already provided. You can study that also. Just for study materials is more than sufficient. You can easily clear the exam. We have included all the questions. You will get the exact same questions, whatever I explained right now. From just for study material, which is having only 28 pages, only 25 pages. All the best. Bye-bye.